I represented myself in court. No lawyer. No team. Just a file in my hand and a chair at the defense table. My wife sat across from me with her attorney, and the man she had chosen over me. They weren't subtle. They didn't need to be. You couldn't even hire a lawyer? Her lover whispered, just loud enough for the room to hear. That's actually pathetic. A few people chuckled. Even her attorney smirked. My wife didn't stop them. She just watched me. Like I had already lost. Like the outcome had been decided the moment I walked in alone. Maybe that's what she believed. Maybe that's what everyone believed. A man without representation looks like a man without power. That's the assumption. And assumptions are expensive. I didn't respond. Didn't react. Didn't correct them. Because I wasn't there to argue perception. I was there to let it collapse. The judge entered. Everyone stood. Proceedings began. Routine. Predictable. Until the moment her attorney started speaking. Confident. Polished. Rehearsed. He laid out their case like it was already finished. Financial incompetence. Emotional instability. Irresponsibility. A narrative designed to make my silence look like proof. I listened. Took notes. Waited. Because timing matters more than volume. And then, mid-sentence, the judge raised his hand. "Counselor," he said, looking directly at her lawyer, "you do not recognize him?" The room shifted. My wife frowned. Her lawyer paused, confused, and for the first time since I walked in, no one was laughing anymore. "My name is Daniel Hayes. I'm 38 years old, and I used to do exactly what her lawyer was doing now, until I stopped. 10 years ago, I walked away from a corporate litigation career most people would spend a lifetime chasing. High-profile cases. 7-figure disputes. Rooms where outcomes were decided before anyone spoke. I knew the system. Not from the outside. From the inside. That's why I didn't hire a lawyer. Not because I couldn't afford one. Because I didn't need one. Should I? I asked calmly, looking at the judge. A small pause. Then he leaned back slightly. "That depends," he said. "Do you intend to proceed pro se with full awareness of the standards?" "I do," I replied. Her lawyer shifted now. Subtle. But visible. Because confidence only feels solid until it meets something unexpected. My wife looked between us. Still confused. Still trying to understand what had just changed. "Very well," the judge said. "Proceed." Her lawyer cleared his throat and tried to continue. But the tone had shifted. The rhythm was off. Because now, he wasn't presenting a case to someone unprepared. He was presenting it to someone who knew exactly where it would break. And I had already seen the first crack. It wasn't in his argument. It was in his assumption. He thought I was alone. He didn't realize I had built this entire situation around that belief. And I was about to use it. He recovered quickly. Good lawyers always do. "Your Honor," he continued, "the petitioner will demonstrate a consistent pattern of financial instability and emotional negligence." Objection. I didn't raise my voice. Didn't stand abruptly. Just spoke. Calm. Precise. The way it's meant to be done. He stopped. Looked at me. Then at the judge. "On what grounds?" he asked, irritation slipping through. "Vagueness and characterization," I said. "No supporting evidence introduced. He's testifying, not arguing." Pause. The judge nodded slightly. Sustained. Just like that. First disruption. Small. But surgical. Her lawyer adjusted his stance. Different now. More careful. He introduced documents. Financial summaries. Selective. Curated. Designed to tell a story without context. I let him finish. Took notes. Didn't interrupt again. Because one interruption is a correction. Too many. Looks like insecurity. When he sat down, he glanced at me. Not mocking anymore. Measuring. Good. That's where I wanted him. The judge turned to me. "Mr. Hayes, your response?" I stood. No rush. No hesitation. And for the first time since this began, every eye in the room was on me. Not because I looked weak. Because they didn't know what I would do next. And uncertainty is where control shifts. I opened my file. Looked once at my wife. Then at her lawyer. And said something simple. "Let's start with the timeline." Let's start with the timeline. I placed a single document on the stand. Not a stack. Not a binder. One page. Clean. Structured. Deliberate. Her lawyer watched it like it might be a trick. It wasn't. It was worse. "Exhibit A," I said. "Joint financial activity over the past 3 years." The clerk took it. Passed it to the judge. then to opposing counsel. I didn't speak again until they finished reading, because silence forces attention, and attention exposes detail. Mr. Hayes, the judge said, eyes still on the page, walk me through this. Line 12, I replied. Her lawyer flipped quickly, then slowed, because that's where it started. Regular withdrawals. Consistent. Predictable. Not from her account. From mine. Transferred into a third-party account. Unfamiliar name. Who is that? The judge asked. I didn't answer. I let her lawyer. Because forcing your opponent to speak your evidence is how you control the room. He cleared his throat. It appears to be a personal transfer. Repeated, the judge noted. Significant, I added calmly. My wife shifted in her seat. First time. Subtle. But real. Mr. Hayes, the judge said, what are you suggesting? I looked directly at her lawyer. Then at her. Then back at the judge. I'm suggesting, I said evenly, that the narrative presented doesn't match the financial behavior. Pause. Then I added. And we haven't even discussed where that money actually went. That's when her lawyer realized. This wasn't defense. It was exposure. Her lawyer stood up again. Faster this time. Your Honor, these are irrelevant personal transfers. Then explain them, I said calmly. He stopped. Just for a second. But in court, a second is enough. They don't pertain to the core issue. They are the core issue, I replied. They contradict the financial incompetence claim. The judge looked between us, then back at him. Counselor, he said, if you're asserting financial instability, these transactions are directly relevant. Silence. Her lawyer adjusted his tie. Bought himself time. Bad move. Time gives clarity. Those transfers, he said carefully, were made voluntarily. By whom? I asked. He hesitated. Because he didn't know. And not knowing in court is visible. I stepped forward slightly. Let me help, I said. Then I placed another document. Exhibit B, authorization logs. The clerk passed it along. I watched his face as he read. That's where it changed. Because this time, it wasn't assumption. It was proof. Those transfers, I continued, were initiated from a device not registered to me. Pause. Then I added. During hours I was documented to be at work. The judge looked up. Sharp now. Focused. And whose device was it? He asked. I didn't answer. I looked at her. And for the first time since this began, my wife didn't look confident. She looked exposed. Because truth doesn't need volume. It needs sequence. And I was just getting started. And whose device was it? The judge repeated. I didn't rush. Didn't soften it. I turned one more page and placed it on the stand. Exhibit C, device registry and login history. The clerk passed it forward. Her lawyer skimmed it first, then slowed, then stopped, because the name attached to that device wasn't mine. It was hers. My wife's fingers tightened around the edge of the table. Your Honor, I said evenly, the transfers were not only unauthorized by me, they were systematically executed from her registered device over a 2-year period. Silence. Heavy now. No whispers. No smirks. Just attention. Her lawyer cleared his throat. There may be an explanation. Then let's hear it, I said. He turned to her. For the first time. Not as his client. As his problem. She didn't speak. Because there wasn't a version of this that sounded innocent anymore. The judge leaned forward. Ma'am, he said, voice measured, were you aware of these transactions? Pause. Long enough to matter. Then. Yes. Quiet. But clear. That one word shifted everything. Because denial keeps things arguable. Mission. Ends debate. Her lawyer sat down slowly. Not defeated. But recalculating. Too late. Because the moment she said yes, this stopped being a narrative. And became a record. And records don't care about perception. The room didn't move. No whispers. No reactions. Just silence settling into something heavier. Her lawyer leaned toward her, whispering quickly. Damage control. Too late. Because once something is on record, it doesn't disappear. Your Honor, he said, standing again, we request a brief recess to confer. Denied, the judge replied immediately. No hesitation. No room. Because this wasn't confusion anymore. It was clarity. Mr. Hayes, the judge said, turning to me, continue? I nodded once. Then placed the final document on the stand. Exhibit D, I said. Property transfer draft and communication logs. The clerk passed it forward. Her lawyer's shoulders dropped slightly before he even finished reading. That's when I knew. He understood. What is this? The judge asked. A drafted agreement, I said, prepared by the respondent and a third party. I let that sit, then added, intended to transfer jointly held assets following a finalized ruling, based on a narrative that has now been proven inaccurate. The judge looked up sharply. Third party? He asked. I didn't look at the lawyer. I looked at the man sitting beside her. The one who had been laughing earlier. Her lover. This one, I said. Silence. Complete. Because now the room saw it. Not suspicion. Not theory. Coordination. And that changes everything. Because mistakes happen alone. What? Don't.